Good morning.
Division 1 of the Court of Appeals of the State of Washington is now in session. Commissioner Jennifer Coe presiding.
Yeah. Good morning. Our first case today is case number 806742, in re the dependency of SEAM. And counsel for appellant,
Yes, Your Honor.
would you like to reserve time for rebuttal?
I would, Your Honor. 3 minutes, please.
Go ahead.
Thank you, Your Honor. May it please the court, Jared Steed, appearing on behalf of the appellant mother, TM. The dependency and dispositional orders in this case suffer from 3 fatal defects, each one of which standing alone requires reversal. First, because the department failed to prove and the trial court failed to find that active efforts had been made, the trial court erred in finding the children dependent and ordering involuntary foster care placement. Second, in the absence of an active efforts finding, TM's acknowledged cognitive deficiencies and the failure to assist TM in accessing services, the court's reasonable efforts finding cannot stand. Finally, in the absence of active efforts, the trial court failed to consider less restrictive alternatives to dependency, such as continued shelter care. Unless directed otherwise, I'd like to start with the active efforts argument this morning, Your Honor.
Go ahead.
A primary purpose of ICWA is to prevent the breakup of Indian families. Consistent with this goal, RCW 1338-130 requires the department to satisfy the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family. The statute does not provide a choice between active efforts or finding that custody of the child by the parent would subject them to substantial and immediate danger. Both findings are required. Subsection 1 reads that the department shall satisfy the court that active efforts have been made. If, as the respondents have proposed in their briefing, the opposite were true, any court could simply dispense with the active efforts finding and proceed directly to determining whether the child was subjected to danger based on placement.
So let me interrupt you. So I think the way I understand your argument is that, because I think I recall from reading in the brief that you're saying that if there is not a finding of active efforts, the trial court lacks jurisdiction to go forward, lacks authority to go forward?
That's correct, Your Honor.
Sure, is that what you're saying? And
That's correct.
The 2 cases that you rely on, ALC and DJS, that's where you get that authority, where you get that support? 2
points to that, Your Honor. The authority comes both from the statute itself, and those cases are instructive in resolving this. This is a question of first impression, I think. But if we turn to the statutory language and we look at 1338-130 and 1338-160, both of those say that if active efforts have not been satisfied and if the child has been improperly removed, the court shall decline jurisdiction. So it stands to reason then that if a court loses jurisdiction, it and the state both lack any power to direct the placement or legal custodial control of the child.
Yeah, you didn't file a reply brief, correct?
We did not, Your Honor.
I'd be interested in your response to, I believe it was the state's motion to consider additional evidence of what happened after the hearings.
Absolutely.
There were additional review hearings and apparently findings of active efforts. Tell me about whether or not to consider that and what difference it should make, if any.
Absolutely. To put it bluntly, Your Honor, we object to the introduction of that new evidence for a couple reasons. One, it would effectively deprive TM of a right to an appeal and consideration of the merits of her case based on the evidence that was available to the trial court at the time the dependency and disposition findings were entered in this case. As the tribe recognizes in its briefing, none of those findings were available to the trial court at the time it made its decision. So they didn't factor into the trial court's decision at the time the dependency and disposition orders were entered. They didn't factor into the trial court's decision from which this appeal stems. whatever findings may have been entered after the fact doesn't change the facts before the trial court at the time, nor its conclusion that active efforts had not been satisfied. And
So let me interrupt you. In your view, once there's a failure to, or there's a finding of or lack of active efforts, then sort of all bets are off and the state has to start again, like has to give the kids back and then start again with a new dependency?
That is our position, Your Honor, and certainly ALC and DJS stand for that proposition, that remand for reconsideration and additional findings are required. To allow the department now to supplement the record with new evidence, as it's suggested it wants to do, is simply a backdoor way for them to attempt to shore up its failure to satisfy its burden at the time that the dependency and disposition orders were entered here.
But under ALC, there was the decision doesn't say that the juvenile court lacked authority to make additional findings, right? We remanded the juvenile court to either immediately return ALC or make a statutorily required finding that returning ALC will subject her to a substantial and immediate danger or threat of such danger.
That's correct. I'm not disputing that is what the case says, Your Honor, but I think it's worth noting as well that the Court of Appeals, in reaching that conclusion, also did not conclude that such a finding meant that the department was not required to prove active efforts, that the trial court could dispense with an active efforts finding, or that a dependency order in the absence of such active efforts findings was appropriate. And we see that again play out in DJS. It's a termination case, but in that particular case, in the absence of active efforts, the Division III actually reversed the termination order and remanded it to determine whether active efforts would have been futile. So those two cases together stand for the proposition, in conjunction with the statutory language, that if active efforts are not satisfied and the child has been improperly removed, then the court lacks jurisdiction. So effectively, the process needs to start over.
Okay.
If I could turn, unless Your Honor has questions about further efforts, I'd like to turn to the reasonable efforts argument briefly.
You want to go ahead and use some of your rebuttal time?
Very good, Your Honor. I'm sorry, am I out of time?
Yeah, you're out of time.
Okay.
Do you want to reserve or do you want to go now?
I would like to reserve the 3 minutes.
Okay.
Thank you.
Okay. And next, is it Ms. Hall?
Your Honor, actually, my name is Ms. DeBell, and I'm presenting for the department on behalf of the state.
I apologize. Thank you. I will give you your 10 minutes.
Thank you, Your Honor.
Go ahead.
May it please the court, my name is Haley DeBell. I'm an Assistant Attorney General representing the state of Washington, the Department of Children, Youth, and Families. The department in this case requests this court to affirm the trial court's finding that the children of the appellant were abused and neglected and properly placed out of home, despite a finding that the department had not made active efforts to prevent removal. The trial court here should be affirmed for 3 reasons. An active efforts finding is not required prior to an order of dependency. The trial court correctly applied the active efforts analysis at the disposition phase. And lastly, the statutory exception to a finding of active efforts for out-of-home placement applies in this case. The endangerment standard, essentially, that the court accurately found that returning the children to the parent would subject them to a substantial and immediate danger or threat of such danger. The trial court correctly found that the department proved by a preponderance of the evidence that the children were dependent in this case pursuant to the definition of dependency in RCW 1334-030 sub 6. This court should accept these orders of dependency as substantial evidence supports the findings of fact and conclusions of law. Given this finding of dependency, the trial court correctly found the children dependent and, in the disposition phase following dependency trial, ordered out-of-home placement despite a finding of no active efforts. The department's evidence presented at trial and the tribal representatives' qualified expert witness testimony supported active efforts. However, the court found otherwise, and the analysis then rightly shifted to that of child safety, the paramount issue in dependency cases and this one. That is whether placement with a parent would subject them to a substantial and immediate danger or threat of such danger. Again, the testimony of the qualified expert witness supported this conclusion, and the court correctly maintained the children in out-of-home placement.
Let me interrupt you. Can you walk me through that one more time about the active efforts finding not required prior to the order of dependency?
Yes, Your Honor, of course.
Just clarify the statutory basis for that?
Yes, Your Honor. A trial court is asked to find dependency by the state pursuant to the 4 definitions of dependency, which none of which include a required finding of active efforts in order to find a child dependent. When we move to the disposition phase, once a trial court has found dependency of a child, for whatever reason, one of the 4 statutory reasons in RCW 1334.030 sub 6, then the court, in ICWA cases, must apply this active efforts finding analysis. That is...
The point being that that's when the decision is made to place the child outside of the parent's care.
Exactly, Your Honor. Because following a dependency finding, a trial court may place a child in home with a parent.
Right,
so
exactly.
There's analysis that has to apply when the department or the trial court decides to place the child out of home. And in ICWA cases, that analysis involves an active efforts finding. But yes, it applies to the placement decision, which is a part of disposition.
So that's separate from the dependency?
Yes, Your Honor.
And is it, I have to go back and look. I'm sorry, go ahead.
So generally, Your Honor, when a child is an Indian child, a trial court cannot order out-of-home placement unless it finds, 1, that the department made active efforts to prevent the breakup of the family, and 2, that the continued custody of the child by the parent is likely to result in serious emotional or physical damage to the child. This refers to a standard of long-term harm, essentially, and is different than this exception that is the crux of this case. So when those 2 findings cannot be made, the law does require that the court immediately return the child to his parent unless, and that language is used in the statute, unless there is a finding that returning the child would subject the child to substantial and immediate danger or threat of such danger. And that finding was properly made in this case. In fact, it exists specifically for cases such as this, where return of a child to a parent would subject her to substantial and immediate danger. The court is not required to find active efforts at the cost of endangering a child. And as a reminder in this case, the evidence that the court heard in finding dependency was overwhelming. The mother had been convicted of assaulting her 6-year-old child on a felony level. She had significant injuries. The condition of the mother's vehicle at the time of removal of the middle child, who was not yet 2 at the time, she was improperly restrained in a car seat. There was rotting food and debris in the vehicle. Additionally, the court heard evidence as to domestic violence in the home, and perhaps most significant, the mother's continued use of methamphetamine from before the first birth of her first child to the last.
But the appellant isn't contesting any of that at this point, correct?
That's correct, Your Honor, but I offer that as a reminder of what the immediate threat of danger or threat of danger would have been if the court were to have returned the children. So the trial court here correctly placed the children in out-of-home care rather than returning to this highly dangerous situation with the mother. And this exact approach was followed in ALC as discussed in the appellant's argument. The Court of Appeals, Your Honor, in that case, endorsed the use of this improper removal standard as a remedy to active efforts not being found. And with respect, the respondent has argued this case to support his position, but eliminates the second and potentially most important phrase of this exception, unless returning the child to the parent would subject them to this danger. So the Court of Appeals in ALC endorsed this standard as a remedy and required the trial court to either return the child or make the endangerment finding. In this case, the trial court declined to return the child, or the children rather, made the requisite endangerment finding, and on appeal, the mother did not challenge the sufficiency of the evidence supporting that finding. Your Honor, the appellant argues in the alternative that a less restrictive remedy exists for this court and suggests that continued shelter care would be an effective remedy. However, Your Honor, we would respectfully argue that this deprives a child of their right to permanency in a safe home or return home. Shelter care is it's a temporary status for a child, and a parent has a right to adjudication of the petition within which they are accused of parental deficiencies. Additionally, an issue with this suggested remedy would be that once dependency is established, a court has authority to impose services on a parent or to order a parent to participate in services that would be reasonably expected to address their parental deficiencies. And as in this case, the mother testified at trial that she was not willing to voluntarily engage in these services, but that she may if they were ordered. So again, extended shelter care would not be of service to either parent or child.
Did the mother request extended shelter care?
She did not, Your Honor. No.
Okay.
Lastly, Your Honor, the mother's argument is moot for the reason that Your Honor raised in respondent's argument, and that is that the initial lack of active efforts finding was resolved by the trial court subsequent to trial. And this is demonstrated in the evidence that's part of the department's pending motion to supplement the record. There were 2 accelerated review hearings that were held within 3 months of the disposition. Typically, the first review would be 3 months out and the second would be 6 months, but we had 2 within 3. And at both hearings, the trial court found that active efforts had been made on the department's behalf, or excuse me, on behalf of the mother by the department. For these reasons, Your Honor, the department requests that the court affirm the trial court's order and disposition, finding the children dependent and placing them in out-of-home care. Thank you.
Thank you. And next, do we have the representative of the tribe?
Yes, we do, Your Honor. Am I coming through?
Yes, and I've got the timer at 10 minutes. So you go ahead.
Thank you, Commissioner Coe, and may it please the court. My name is Weston LeMay, arguing today on behalf of Respondent Intervenor Swinomish Indian Tribal Community. The tribe asked this court to affirm the lower court and dismiss this appeal for 3 reasons. First, because the trial court properly followed the clear mandate of ICWA Section 1920 and WICWA Section 160 by not returning the children to a dangerous home. Second, because in cases like this one, courts can and should retain jurisdiction in order to ensure child safety and continue to enforce active efforts. And third, because the underlying child endangerment finding under ICWA Section 1920 was supported by substantial evidence. Commissioner, this case turns on the trial court's finding under ICWA Section 1920 that returning the children to appellant's care would subject them to substantial and immediate danger. And it's worth noting the seriousness of the facts supporting that finding. This is not a case about returning a child to a messy home. This case began when appellant's felony physical abuse of her young daughter, causing that child and the child's younger sister to be removed from appellant's care on an emergency basis. Appellant later gave birth to a 3rd child who was removed when both baby and mother tested positive for methamphetamines. The Swinomish tribe has a duty of care to these children because all 3 are either Swinomish tribal members or eligible for membership, and the tribe intervened in the state court dependency proceedings below out of concern for their safety. With children this young, to say they're vulnerable would be an understatement. In the proceeding below, although the department had not adequately demonstrated active efforts at that time, the trial court separately found that returning the children to appellant's care would subject them to substantial and immediate danger or threat of such danger under ICWA Section 1920 and RCW 1338-160, the parallel provision of WICWA, which adopts nearly identical language. I refer to both generally interchangeably in this argument. The trial court ordered continued out-of-home placement as a result of this endangerment finding. Commissioner, the tribe argues today that the trial court's decision correctly prioritized the safety of the Indian children, as does ICWA and as does WICWA. In this case, the adequacy of the department's active efforts does not control the outcome. The ICWA Section 1920 finding does. Ultimately, this case is not an active efforts case. It is a remedy case that asks what juvenile court should do when active efforts are not shown. There is a difference between the requirement of active efforts and the remedy that courts should follow when the state fails to make that showing. If, as here, the child cannot be safely returned, the answer is not, as appellant argues, to simply return the children anyway. This would unjustly expect the Indian child to bear the risk of physical danger as a result of the state not adequately making its active effort showing. The tribe is deeply uncomfortable with the implications of this argument and would argue today that it's contrary to the prioritization of the best interests of the child that runs throughout these statutes. Instead, the correct remedy is what the court did below: to maintain jurisdiction, to ensure the child's safety, and to enforce active efforts through other means. Commissioner, there were three findings of relevance below. The first, that through the appellant's continued custody, there would be the likely result of serious emotional or physical danger or damage. That's 1912E in ICWA. Second, as we've discussed, the department had not adequately demonstrated active efforts under 1912D. And third, most importantly, that under ICWA Section 1920 and WICWA Section 160, that returning the children to appellant's care as a result of the second finding was an unacceptable option because it would subject them to substantial and immediate danger. By arguing that the showing of active efforts automatically requires return, by arguing, as appellant did in his brief and today before the court, that the court lacks jurisdiction immediately upon a finding that the active efforts threshold has not been met, appellant focuses on the first two findings, but generally ignores the third. Commissioner, appellant today repeated this argument and did not simply continue to read the clear statutory text of 1920, which contemplates the exact situation presented by this case and clearly instructs courts as to the proper remedy. Your Honor, I'd like to discuss the DJS and ALC cases, but with respect, the court need not turn this decision on whether those cases support or don't support appellant's position, because here all that's necessary is following the clear and explicit statutory instruction, as the trial court did below. Section 1920 reads that if removal has become improper, and the tribe would agree that a removal where active efforts hasn't been shown is improper, that courts should decline jurisdiction and return the child. But 1920 does not stop there. It continues, unless doing so would subject the child to substantial and immediate danger or threat of such danger. And as I've said, RCW 1338-160 adopts nearly identical language. In this case, the trial court made that child endangerment finding, triggering the second half of this provision. Now, that finding has no impact on the department's overall obligation to demonstrate active efforts. Instead, the endangerment finding under ICWA Section 1920 impacts the remedy for improper removal. While the normal remedy would be to return the child, as appellant correctly argues, here, this case is different because of the 1920 finding. That puts us on a different path. ICWA Section 1920 operates as a clear statutory exception that expressly forbids the typical remedy if return would put the child in danger. In the 1920 scenario, ICWA and WICWA instead required juvenile courts to maintain out-of-home placement until the endangerment finding is either reversed or the case is otherwise resolved. Now, appellant has argued that adopting this approach would simply allow courts to skip the finding of active efforts and go straight to whether or not there was danger for return. And the tribe would disagree with that. And the reason, as I'll discuss in a moment, is because active efforts is an ongoing requirement that, as the tribe reads the statute, kicks in from the moment of a CPS referral all the way through the termination of the case. But second, and more importantly, these are separate findings. And what we have here is a distinction, a confusion in this case between the requirement of active efforts and what juvenile courts should do when active efforts aren't shown. So the second prong of ICWA 1920 doesn't address the requirement of active efforts. It certainly does not waive the requirement of active efforts if we do have a 1920 finding, as we have in this case. What it does is tell courts not to take the traditional remedy. It tells courts, of course, if returning the child would subject them to danger, don't do that. Instead, maintain out-of-home placement. And I think the missing link here is, well, how are courts to enforce active efforts if the response to the state's failed showing is simply maintaining the status quo? And the answer to that is that returning the child does not actually achieve active efforts. It merely cures the ill of not showing active efforts. And so that's not actually a remedy for it. Instead, by maintaining out-of-home jurisdiction, you prioritize a child's safety, and the court has a range of other discretionary authorities and abilities in order to continue to enforce active efforts. And the state has already referenced some of these, which would be increased and more frequent review hearings. And that is, in fact, what happens in this case. Whether or not the court is inclined to grant the state's motion, we do at least have within our appellate record today that the court did immediately schedule one additional review hearing to continue to check the progress towards active efforts. Now, I'd like to take just a moment to emphasize that active efforts are to maintain or reunite Indian families under 25 CFR 23.2. Because we have an emergency removal here, the focus is on reunite. This is an ongoing obligation and speaks to the heart of ICWA and WICWA. Commissioner?
Let me just interrupt. So you would disagree with the state, or to the extent that I understood the department to be saying that active efforts is a question for the disposition rather than the dependence. But because you're saying that active efforts is something that starts at the beginning and goes all the way through. But I see what you're saying as far as the active efforts in this case would be to reunite because they'd been emergently taken away from the parent. But what you're saying, I mean, it might be a subtle difference, but is that correct?
That is correct. Commissioner, may I very briefly respond? I do see I'm out of time.
Yes, please.
I think it's no surprise that the tribe and the state have a different view of active efforts here. They're separate sovereigns. They have different interests involved. And yes, Commissioner, we would say that the most accurate view of the statute is that thinking of active efforts as a box to be ticked at a single hearing or another hearing, a single point in time in the case, is simply fundamentally the wrong way to think of active efforts. If active efforts are about removal, prior to removal, well, clearly they have to happen at some point running up prior to removal. Here we have an emergency removal, which does waive the active efforts requirement. But if it's about reunification, then those attempts have to be ongoing. So the distinction of whether it's before dependency or disposition, because although those are granted more likely than not very close together in time, is perhaps the wrong way to look at active efforts. It's an ongoing obligation about how to prevent the removal or to facilitate the reunification of Native families. Commissioner, if I may briefly conclude in one sentence, it cannot be that ICWA and WICWA force us to choose between enforceable active efforts and the safety of Native children. The tribe urges this court to affirm the lower court and dismiss this appeal. Thank you very much.
Thank you. And appellant has now 3 minutes remaining. Oops. Go ahead.
Thank you, Your Honor. I just want to turn briefly again to the statute because there seems to be some dispute about the statutory language here. There's a focus by the respondents on the word unless. If we look at 1338, 130, subsection 1, a party seeking to effect an involuntary foster care placement shall satisfy the court that active efforts have been made. Shall signifies this is a duty. This is a requirement. There is no or between subsection 1 and subsection 2. Rather, what subsection 2 further holds is that after active efforts have been proven, an involuntary foster care placement still may not be ordered unless there's clear and convincing evidence that the continued custody would likely result in the serious emotional or physical damage to the child. Now, I want to go back to the issue of supplementing the record briefly and point out that 9.11 should only be used in extraordinary circumstances and only when these 6 factors are demonstrated and proven here. Again, to allow the respondents to supplement the record at this point in time is simply a backdoor way for them to attempt to shore up their evidentiary shortcomings and failure to satisfy their burden of proof at the onset.
I understand that, but I want to actually focus your attention on something else, if that's possible.
Absolutely.
So I would like you to respond to the tribe's argument, which honestly I found compelling. This idea that in this particular case, there was an emergent removal of the children from the parent. And so the statutory requirement of active efforts is the department should be making active efforts in reunifying the family, in reunification of the family, correct? So is that correct, number one? And number two, my next question would be, by saying that the remedy for the department's failure to show active efforts, make active efforts, would be the immediate return of the children. I mean, like the tribe was arguing, that actually doesn't remedy the problem of the department failing to make active efforts, correct?
Well, let me take your Honor's questions in turn and make sure I understand them correctly. So, first of all, I think it's important to clarify the record here, okay? The children were initially removed based on an emergence, but ultimately, the reason that removal continued prior to dependency and disposition was because TM entered an agreed shelter care order, okay? So at no point was there a finding that the emergency continued or that it needed to continue. Essentially, that point was mooted out by the sheer fact that my client agreed to that. To the extent that there was a continuing emergency that warranted continued removal, I mean, we don't even get to that point because we don't have the department proving active efforts, which means that the alleged events that resulted or needed a emergent removal were never cured or attempted to be cured in the first place. And so, this is not a situation where the respondent's sort of parade of horribles is going to come to pass because we don't even get to that question because there was no effort by the department or the tribe in curing what it alleges was the basis for the removal, whether agreed or otherwise to begin with. And I'm sorry, Your Honor, what was your second question? If I've said
I think you've answered it. So why don't we just go ahead and wrap up? I used up all your time.
Okay. Very good, Your Honor. Thank you.
Thank you.